One of the core things that we need to understand is recognize what is meant by intellectual property. Now, for us to kind of understand what intellectual property actually means, let's try to understand that using a very simple example that each of us could ideally relate to. So what we have here is essentially different aspects of, let's say, a company like Mercedes-Benz. So to begin with, I have something that looks like an engine. So typically, when we think of an engine, we take kind of associate it with technology, right? So we have an engine, and we typically associate an engine with a technology. So similarly, within the same company, you have, let's say, the car itself, the way that car looks, right? So we are essentially now looking at the aesthetics of a product. Initially, we looked at some aspect of technology. Now we are talking about the aesthetics of a product. Now, moving on, we look at this rim, which these three fins, essentially, it is the logo of Mercedes Benz, right? So, this is essentially the brand of the company. Then the fourth example is manual that probably comes with this particular car, which essentially tells you how exactly you need to be using various features of this particular automobile, which is essentially the literary work that kind of comes with this particular product. So we see that within this company itself, you have, technology that has been created, some aesthetic design that has been created, a brand that has been created, and some kind of a literary work that has been created. And all of these things have been manifested in a physical form, right? So you have a physical engine, likewise, we have a physical car, so on and so forth. Now, this is where the interesting part kind of comes in, right? So you have all of these things in the tangible form. So what it means is that if somebody were to, steal this particular engine, then you would say that the tangible property has been stolen from this particular company. On the other hand, let's suppose, nobody is actually stealing this particular engine. Instead, what they do is they copy that whole technology of that particular engine and then create their own engine by copying the entire technology, right? So intuitively, we kind of know that what has been done here, which is copying of that particular technology, is also some kind of violation, right? Although the physical form of it itself is not being stolen, some kind of an intellectual aspect of it has been stolen. So likewise, let's suppose I come up with a car which exactly looks like the car that is here. Again, we kind of have this instinctive feel that, okay, again, even in this particular case, the looks of it has been stolen, right? So likewise, let's suppose I come up with an automobile and then use this particular logo on that particular automobile. Even in that particular case, again, some kind of an intellectual aspect of it has been stolen. So similarly, the last example, so let's suppose the content of the whole book, I reproduce that whole content and then use it for my own purposes. Even that is some form of stealing, right? So you have different forms of intellectual property or intangible property. On the one hand, we have technology, then we have the aesthetics of a product, then we have the brand of a product, then we have the literary work. So all of these things are kind of distinct in nature. Now, because they are so distinct in nature, there has to be some unique and distinct ways of protecting each of these different types of intangible property or each of these different types of intellectual property, right? Now we will talk about what are those distinct ways of protecting each of these types of intellectual property. Now, when we talk about technology, technology can be protected by what is called as patents. We will be talking in greater detail as we proceed further in this presentation about patents. So likewise, when we talk about aesthetics of a product, it can be protected under what is called as industrial designs, or in some jurisdictions or in some countries, it is called as a design patent. While technology can be protected under patent, in some countries it is referred to as a utility patent, And when it comes to aesthetics of a product, it can be protected under industrial design, or a synonymous name for the same is a design patent, right? So patents is for technology, and design is for aesthetics. Moving forward, brands can be protected under what is called as trademarks. And lastly, the literary work can be protected under what is called as copyrights. Now, there are multiple forms of intellectual property. So here we are talking about four very broadly used forms of intellectual property protection: patents for technology, industrial design for aesthetics or how a product looks, trademarks for brands, logos, so on and so forth, and copyright for literary work, and so on and so forth. Now, among the different types of intellectual property that we are referring to here, the two most common used protection is for technology and brand, that is patents and trademarks. Now, in this presentation, we will be talking in greater detail about patents and trademarks.